So good morning, everyone, and welcome to this fifth edition of our Lunch and Learn series. These seminars are organized as part of the Chair on Content Moderation, a project that is funded by the Ile-de-France region. And the focus of our work is the regulation of online content moderation and the legal frameworks that address these issues. Today, we have the pleasure of welcoming Thomas Hughes, with whom we will explore the inner workings of out-of-court dispute settlement bodies, which is a new mechanism that has been established under the DSA. Following his presentation, which will last around 20 minutes, we will open the floor for discussion. Thomas Hughes is the CEO of Appeal Center, one of the certified ODS bodies pursuant Article 21 of the Digital Services Act, and he's also the former director of the Meta Oversight Board. And prior to that, he was the executive director of Article 19, which is an international human rights organization that defends and promotes the right to freedom of expression and information. He has therefore extensive experience in the context of platform governance, and he has worn different hats, which makes his contribution really, really insightful. As we know, under the EU Digital Services Act, users are given the possibility to challenge content moderation decisions by lodging a complaint to an out-of-court dispute settlement body. And there are currently 8 bodies that are certified to settle content moderation disputes between users and online platforms, and Appeal Centers is one of these. This body has also recently published its first transparency report last week, which has included very interesting findings, such as the fact that more than 75% of their decisions overturned the platform initial decision and found in favor of the users who had submitted the case. So I will stop here with my introduction to the topic, and I will give the floor to Thomas. Thank you once again for being with us, and we look forward to hearing your insights on this new out-of-court dispute settlement bodies. Thank you. The floor is yours.
Stefania, thank you very much, and thank you again for the invitation to join you on this Lunch and Learn session. To the degree possible, I will give a presentation, and I will answer, Stefania, as precisely as I can the questions that you've asked of me. But to the degree that anyone has any questions or comments as I go through this, do please shout. I'd love this to turn into as much a discussion as a presentation. So I think the place to start is obviously a brief introduction to the Appeal Center Europe, the organization which Stefania mentioned that I'm the CEO of. I'll give you a very technical description of it to begin with, but I think as I go through the questions, Stefania, that you've asked me to answer, that will really bring to life what some of these technical points actually mean in reality as people raise disputes about the content moderation actions that the large social media platforms are taking in relation to content that they themselves have posted online, but also content that they see online that they think might be violating. So we are a very new institution. We started at the end of last year, and as Stefania mentioned, we're amongst the first of the ODS bodies created in the EU, of which there's now just over about half a dozen. We are certified in Ireland by the National Digital Services Coordinator in Ireland, which is called the Commission Naman. And they're, of course, the governmental regulator. And we are certified as a pan-EU body, so we cover the entirety of the EU, all EU countries. And we are certified to address disputes in relation to online social media platforms. And we have started with those platforms that are designated as VLOPs by the European Commission, so the very large platforms. And at present, that includes for us, Facebook, Instagram, Threads, TikTok, YouTube, and Pinterest. But we will be making over time our way through the list, as it were, to bring on board other platforms. And I assume this might be a question. I get asked this a lot. So X, yes, is included and is one of the next ones on our roadmap. We are certified to cover policy violating content. So that's essentially harmful content. We're not certified to cover illegal content. But as you can well imagine, the vast majority of illegal content is also policy violating content. But we would look at that from a policy violation perspective. And very importantly, as we apply platform policy, we do so with consideration for fundamental rights and international human rights standards. So again, I can come back to that in a little bit more depth, exactly what that means. But it does mean that it is not just a verbatim application of platform policy. And there's nuance within the application of platform policies, because platforms themselves don't just apply their own policies, they have exceptions and principles and also internal guidance and so on and so forth. We cover all policy areas, so anything that is policy violating can be brought to us, with the exception of areas that we have deemed to be sort of the most egregious areas. So we don't cover, for instance, CSAM, and we don't cover, because it's outside of the scope of the legislation, we don't cover things that are purely behavioral. So behavioral content moderation actions that have no implication in regards to the sharing of information. So things like spam, for instance, would be out of scope for us. We handle content in all languages, almost all languages spoken in the EU, and we function with 6 procedural languages, soon to be 7, and those are the most widely spoken languages in the EU. And we handle what we call simple objects, so that's videos, comments, posts, but also account suspensions. And our decisions are basically to either restore or remove, or to apply an interstitial, so like a warning screen. We do intend to look at issues like demotion in time, but again, that's a very complex question, and we're not there yet, as we've only really been in operation for just over half a year. So let me turn to the first question, and I think, as I mentioned, Stefanie, I think your questions will help breathe some life into that sort of very technical description of the Appeal Centre Europe. So the first one relates to what is the value of the decisions within the DSA machinery. So I think, as everyone probably on this call is aware, the Digital Services Act creates quite a complex ecosystem of different processes and procedures and institutions. And I think there is beauty in that complexity within that legislation. I like to think of it as sort of a series of internal and external processes and compliance requirements. And obviously within the internal platform-facing requirements, there are things like points of contact and transparency reporting and notice and action and internal appeals and access to data and mitigation of systemic risks. So those are requirements that are placed on the platforms. But within the external set, and here I think it comes to the part of the beauty of the legislation, you see a series of, or a network of, non-statutory entities, bodies and functions. And the importance of the non-statutory piece there is that it removes from direct, necessarily governmental control, issues around freedom of expression and application of fundamental rights, which is obviously very important in order to maintain a rights-respecting ecosystem. And there, within those sort of external bodies, you've got obviously the things like trusted flaggers and vetted researchers and the auditors for systemic risks. But amongst them, obviously, is the out-of-court dispute settlement bodies. And for me, the ODS bodies are the most obvious and I think accessible point of engagement for the average person in the EU, for the average citizen or person located, I should say, in the EU, and also for that matter for many organizations in the EU that also want to make use of out-of-court dispute settlement. And essentially, it really allows people, I think, for the first time in a realistically accessible manner, to take more control over their digital ecosystems and have more control over their social media feeds in a way that they really didn't before, or were solely dependent on the platforms and the largesse and goodwill of the platforms to be able to exercise. And I think, as everyone again is aware, there were lots, and still exist to be lots of problems within that kind of ecosystem of direct engagement, where direct engagement is required of the platforms. Now, of course, platforms do actually a remarkably good job, if I can put it that way, of handling the vast majority of harmful and problematic content on their platforms through both human and algorithmic treatment of content. But there is still, because of the sheer scale of it, a very large number of decisions that are either erroneous or wrong, or have a application of policy, platform policy, which we would certainly disagree with based on our normative framework. And although that is measured in very low percentages, due to the scale, that is still many tens or hundreds of thousands of individuals who are affected. So having a cost-effective, i.e. free, timely, as in days or weeks, not months or years, route that doesn't require enormous amounts of legal knowledge to access, I think is extremely important. And the ways in which, of course, it can impact is it gives the individual or the organization access to immediate redress in a realistic manner, as I've mentioned. But the decisions are, of course, non-binding. And to answer, Stefanie, another question that you asked, there is no requirement for the platforms to replicate decisions across different cases or to use the decisions to inform policy changes on the platforms themselves. But what the decisions will do, and there's a tie back in the legislation between Article 21 that deals with out-of-court dispute settlement and Article 35 that deals with systemic risk. What the out-of-court dispute settlement decisions do is create what I like to think of as a heat map. So where decisions are not implemented, the regulator, I think, or the auditor who is responsible for systemic risks, I hope will look at patterns that you can see emerging. For instance, there is a lot of hate speech with this type of slur word in this language, in this city, targeting this community. Like, they will take that and they will say, well, that is a systemic risk, right? There's a repeated pattern of harmful content being posted and not being removed. You've got these out-of-court dispute settlement bodies that are saying, no, this is violating, and it's not being taken down. So that becomes a systemic risk, and then it goes into another form of regulatory review. So again, the impact of out-of-court dispute settlement doesn't stop at the decision itself. There are further points in which this connects. And then you can also imagine a way in which, hopefully over time, the legislation and the different parts within the legislation start to connect more effectively, so that you've got, you've got the vetted researchers also utilizing decision data, and you've got ODS bodies being informed through vetted researchers to the policy standards that they would set. And then you've got trusted flaggers who are flagging illegal content. So you've got these different bodies that will start to benefit from one another's work and the data that we can respectively put out. Now, we're not there yet, but I hope that we're not far away also from sort of starting to realize some of those interlocking mutual benefits of the legislation. So to the next question, what is the basis for decision making? What standards do we apply? So as I mentioned, we are certified to look at policy violating content. So we apply the platform's policies, but we do that with consideration for any principles or exceptions that the platform themselves apply. And we also do that with respect for consideration of human rights standards, but also very importantly, the different tests that exist within international human rights law. So things like the Rabat Plan of Action, or the three-part test on Article 19. And that helps us to understand whether individual cases, and within all cases, context is king. So the circumstance and the situation is always vital to understand the potential outcome. That really helps with the application to those individual cases. In terms of scale, so as Stefania mentioned, we just published our transparency report last week. I would really encourage everyone to have a look at that. It's available online. So we have received 10,000 disputes to date. About a third of them, so 3,300, are eligible. And again, I come back in later to say why the 2/3 are ineligible. And we've issued about 1,500 decisions. And I think this is the tip of the iceberg. I think this really proves the interest and the relevance that exists for people to make use of out-of-court dispute settlement. And I think it will grow over time, although I do not believe it will grow exponentially. Sometimes I'm asked, when you look at the EU's transparency database and the sheer number of now billions of content moderation actions, although many of them would be in scope, not all by any stretch, but many would be in scope. If you look at equivalent bodies who are doing in a very different way, different work, but bodies like the Oversight Board and the amount of appeals they receive from Europe, again, they're measured in the sort of the 140,000 a year kind of realm. And that is for the wider European region, not just the EU. So, and if you use that as a kind of an inaccurate comparator, then I don't think there's just a sort of an endless exponential growth. But I do think the 10,000 that we've received is as a starting sign of initial interest. And as I say, definitely of relevance. In terms of the time frame, so the law provides 90 days to review a case, or 180 in complex cases. When we began, we were on an average of 115 days to review a case. We're now down to 19 days. My aspiration is that we can bring that down to single-digit days, but that will require more engagement from platforms, more compliance, and so on and so forth. But I think that is very achievable, and I would like to see the 19 days reduced as we go through the course of next year as well. In terms of the outcomes of decisions, so in 75% of the time, we are overturning the platform's decision, and in 75% of the time, we are actually making decisions to restore content. So again, there is this narrative that's being pushed that somehow regulation in the EU is contrary to freedom of expression standards and is a censorship tool. That is not correct, right? I think regulation in the EU is a defense and a promotion of freedom of expression, and some of the mechanisms like out-of-court dispute settlement show content being restored that is wrongly removed. I think it actually pushes in the opposite direction in terms of that argument. I would note, though, that those stats, they are a little bit masked by what we call default decisions. So we issue a default decision where the platform has either not engaged sufficiently with us, cannot find the content when we've requested it, or refuses to give us the content. So there are quite a number still of default decisions, and we are talking to platforms of how to reduce that number and to provide more satisfactory outcomes. But those statistics I quoted earlier are somewhat masked by the number of default decisions as well. Main policy violating areas, so hate speech, adult nudity, bullying and harassment are the big ones. Main countries that we're receiving, so Poland, France, Italy are the three big ones, but per capita actually Lithuania, Slovakia and Poland are the largest countries. So again, some interesting early days, but interesting patterns emerging. And again, in answer to the question, financing, we, like all the other ODS bodies, are financed through fees that we charge to the platform. Those fees vary depending on the out-of-court dispute settlement body. We have also received a one-time irrevocable grant from an institution called the Oversight Board Trust that was set up in 2020. That was set up by Meta, but I would stress that that was, as I note, one-time irrevocable. We went through a very thorough certification process with the Commission Man, the national regulator in Ireland. We are entirely separate from the Oversight Board, so that ensures our independence and our impartiality. Are platforms complying with the regulation? I would say yes and no. So it's a mixed picture. We think about this in kind of four main buckets. You've got signposting. So that's the platform, that's the information that the platforms are required to put on their platforms that tell people about their right to appeal or a right to raise a dispute through out-of-court dispute settlement. It's set out in the legislation. They're required to do this. The next one is the data sharing piece. So do they share data with us, both from a GDPR compliance perspective, but also from a sufficient data to be able to issue a decision? Are they in agreement with us on our scope and what is an eligible case? And have they put in place the technical requirements to be able to transfer that data back and forth? And obviously there's different levels of sophistication within that. So to talk specifically about the platforms, so Pinterest, who we've only just started with, is very early days. So they were the most recent one to come on board. They have good signposting. We've got all the data sharing agreements in place. There's, as of yet, no dispute about scope. And technical arrangements remain, as with other platforms, really sort of based on more rudimentary engagement, but again, with the aspiration that we will get to become more sophisticated over time. With Meta, again, relatively good signposting, some areas to improve. Data sharing, we have a data controller to data controller agreement in place, very good data sharing agreement in place. Scope and eligibility, lots of areas where we're sort of pushing back and not in agreement as to the scope. As you will not be surprised to hear, platforms generally agree on sort of, let's say, a core scope of issues. But when we start talking about other areas that we think should be in scope, or not should, are in scope under the legislation, then you get into grey areas of discussion with platforms where there is pushback, and that leads obviously to default decisions. And technical arrangements are also very good. I would say with TikTok, again, signposting okay, but certainly areas for improvement. Data sharing is fine. Again, areas of discussion like with Meta on scope and eligibility, and technical engagement we hope over time will improve. They've said to us that they have the intention, so hopefully that will get better over time. YouTube, so not very good signposting. Data sharing very poor. In fact, they've given us no data in relation to any content. So data sharing is a real problem with YouTube. We released our transparency report last week. They, in some of the media report, came back and said that we've not put the right privacy protections in place. That is a disingenuous response. We have very high and robust standards of data protection. We have managed to sign or set out data sharing arrangements with all the other platforms in much shorter time frames. But unfortunately, our engagement with YouTube is punctuated by very large, long periods of silence. And it has not been a particularly productive relationship to date. So that is somewhat unfortunate. But of course, we hope that in time, in short time, that situation will improve. And I'm running up against my 20 minutes here, but the last question is coordination between out-of-court dispute settlement bodies. Has there been much, and can we improve standards and efficiency? So yes, we have created, with all the other certified out-of-court dispute settlement bodies, what we call the ODS network. Now, all of those bodies are different in nature and approaches. You've got some like us who are sort of purpose designed and built to do out-of-court dispute settlement, and we seek to do that on quite a technical but also potentially scalable manner. You've got other bodies which have backgrounds as ADR entities under previous EU legislation. You've got others that sort of have come from more statutory background, like in Austria, where the government has been more directly involved in the creation of their ODS. And then amongst those, you've got some that are specific to different languages or different countries, or specific to different types of platforms. So it's a mixed group, but we have very confident, very good working relations with one another. We meet frequently, we discuss standards, we share information, and we seek to, where possible, engage with platforms in a coordinated manner to sort of set out areas where we think there should be improvements, and we seek to do likewise with the regulator as well. So far, a very promising sort of initial period amongst the ODS community, and I'm confident and hopeful that will continue in the future. Stefania, I will stop there and hand back to you.
Thank you so much. Thank you for the interesting presentation, which I see it's already sparking questions also from my end, but I think I'll keep them for now and maybe leave them for later. So we have a first question from Bastien. I'm going to read it out also for everybody. So hi, thank you for your presentation. Your report shows that platforms are not engaging that much so far, either because they don't share the content in the first place or because they decide not to implement the decision afterwards, which is their right, but I understand that about 50% of decisions are not implemented. Would you consider that a violation of Article 21 if it continued in the future beyond the launching period, and could you consider acting on it?
Yeah, so I think how you read the report is a glass half full, glass half empty sort of discussion, right? So yes, we have sort of receiving data and issuing decisions from platforms in about half the cases. I think you could read that to show that there is good intent on the platforms to share data and to make out-of-court dispute settlement work. You could equally argue that there is insufficient engagement from platforms on the other decisions where we are not receiving sufficient information. Now, a lot of those are either because the platforms are unable to locate the content. So each time we receive a dispute, we require the user to give us certain types of information in relation to that dispute, and the information that's required we have made sure is what is required by the platforms in agreement with them in advance. But nevertheless, quite often, the platforms, due to their own internal systems and processes, are still unable to locate the content. Even in cases where we have the URL of the content and can see it online, they're still unable to locate the content within the system that they need to use to undertake content moderation. So there are definite improvements that platforms need to make to be able to identify content. My understanding from those platforms is that they are trying to make those improvements. So I hope to see an improvement over time. And I think because this is such a new sector, there should be some small degree of acceptance that this is a journey where we need to see improvement, and that it will take time and resources to get there. Again, I am more eager than anyone to see that improvement happen fast, right? But it does require time. And then the other section is where there's dispute over scope. So where they say, well, this content is hosted and located outside the EU, or this is a language that you're not certified to cover, or this is just a behavioral issue. It's not an information sharing question. So those are areas where we are pushing back, where we are very confident that we have understood the legislation correctly, but in the end of the day, might need the regulator to clarify, might need them to say, no, just because it's located outside the EU doesn't mean it's not in scope, or no, different strikes and an account suspension, they are eligible, right? They are in scope. So there are certainly areas where there is disagreement between, but I hope and I'm confident that we will see the number of decisions in terms of not being or being deemed for default decision, eligible for default decisions, will be reduced over time. Implementation is that's still to be seen, right? So we have requested of the platforms that they inform us about the outcome of their implementation. To date, we've got a relatively small number of responses back. That is not necessarily because implementation is not happening. It's because tracking implementation reporting back is still a new function and a new element, and is not strictly required under the legislation. So again, we hope to see progress there. But what I would also stress again is that I would really counsel everyone not to think of out-of-court dispute settlement as solely about redress, right? It is about redress for the individual. That is extremely important. Everyone should have the right to be able to have that review. But where individual redress, i.e. implementation, is not actioned, I think that there is an even sort of more powerful secondary function connected to the systemic risks, as I outlined earlier. And where we see repeated patterns that are of sufficient impact that they require a product or a design change, where there is a cumulative rights-based impact on users because the platforms are not acting, that will only really be derived from areas where the platform's decisions are not being implemented, right? That'll be well, not solely, right, but that will be the clearest picture of where that happens. So I think there will be a secondary element within the legislation in terms of change that can be achieved from the platforms.
Thank you so much. We have another question from Susanna, who is the director of the chair that also did these events. So thank you so much for your amazing presentation. I really enjoyed your quote, "Context is king," because I think it's essential. However, the statistics are showing that when a platform removes content, it does so uniformly, 99% across the EU. See this article, and it's a reference to a recent study. What do you think that shows? And I think I'll jump in here because I have a related question to this. So you mentioned also just now that a secondary function of the out-of-court dispute settlement is this idea of providing a heat map and looking at patterns so that you can identify systemic risks. And so one of the interesting findings in the Appeal Center report is this sort of data pertaining to countries specifically. And I think this brings me back to Suzanne's question: to what extent does this data help also in contextualizing systemic risks within specific countries or across specific languages? And what is the benefit of having this sort of information, and do we need more?
Yeah, thank you. Yeah, so I mean, obviously, content moderation on platforms is at scale, right? I think we all recognize that, and I think everyone understands the challenges that are accompanying that. The fact that out-of-court dispute settlement exists, and the fact that context is always king, right, when it comes to individual decision making, I think that just demonstrates the importance and the value of allowing users to be able to access a tool like ODS, because it means that where mistakes are made, and again, those mistakes are often sort of measured in low percentage points, right? If you look at the platform's own reporting, nevertheless, that's still hundreds of thousands of potential actions that these platforms are taking in relation to content that people have posted up or content that they see that is violating. So directly connected to their expression and free speech rights, that is impactful and potentially extremely momentous in every individual's personal life, right, to them, in their context, even if it's not necessarily a dispute or a case that has sort of a regional, national sort of impact. So I think that just does reinforce both the question that there is this huge challenge that platforms face, that the replication of standards across so many different languages, jurisdictions, local context settings, individual lives is a near impossible task, but just reinforces the importance of giving people the opportunity to challenge those decisions where they are wrong, where they believe those decisions are wrong. And in relation to systemic risk, I would say absolutely. One of the repeated points that is being raised to us now as the Appeal Center, but I've heard time and time again in previous roles, is particularly, as you move away from maybe English and French and German as kind of core languages where more investment is put in by the platforms. And really, actually, I think we have to acknowledge that sort of English is the one that gets the most attention, the primary attention, and even other very large, significant languages in the EU and global languages just don't get the same resourcing. But as you go down that scale and you get to smaller languages, not just official EU languages, but smaller languages spoken by communities across the EU, you know, the resourcing and investment that comes from platforms becomes very low, very minimal, and the scale of potential problematic content, like, you know, we as you can see from our transparency report, one of the surprises for us was the sheer scale of hate speech that we were seeing, and I think it constitutes about 38% of the disputes that we receive. Now, when you get to the smaller languages and the smaller regional or local context, that goes up. Our experience is that number starts to climb, because there's just not the attention to detail, and there's not the local context and knowledge to be able to moderate the content effectively. So I think that, again, just really reinforces the fact that this will help identify where those systemic risks lie, and they don't just have to be risks that, you know, are speaking at a pan-European or in the major language sets, right? Systemic risks can equally appear in a smaller EU language, in a smaller context, in a local environment or city. So yes, I hope it's going to be very helpful in that way.
Thanks. Thank you so much. We have another question from Bastian Carniel. Hello, Thomas. Thanks for the presentation. You briefly mentioned going beyond take down, live up. For example, hoping to handle downranking down the line. You mentioned interstitials, but I didn't quite get it. Is this something you currently do or something you hope to do? What would this apply to? For instance, violent content that should have a banner over it but doesn't. B, what would that also apply to monetization? For example, on YouTube, ad displaying against content that likely breaks YouTube monetization policy.
Great question. So we are bringing in now interstitials, so the application, but also to challenge the application, but also to include recommendations for essentially warning screens over exactly the type of content, Bastian, that you mentioned there. We've also just bringing in now advertising and advertising policy. I'll have to come back to you and say whether we will actually be using interstitials in relation to advertising as well, because I don't know the answer to that question at the moment.
Thank you. I don't know if there are any other questions, but while people type their questions, I'll take the opportunity to ask another one. So you mentioned that with respect to the basis for decision making, you consider both platforms standards and policies, but then also consideration for international human rights law. So I attended another event with another ODS body, a similar workshop with user rights, and I asked exactly the same question. And if I understand correctly, their approach is more focused on platforms standards plus EU fundamental rights, and so mostly the European Convention and case law. What sort of standards are instead taken into account, and is this analysis constantly performed, or I don't know, are also the platform standards assessed against human rights when you make these decisions? How is the decision-making process structured in a way? Thanks.
Yeah, so based on your description of the user rights process, I don't think there's an enormous difference between the process that we have in place and what user rights does. I'm sure there are some differences, but we essentially will look at a particular dispute. If the policy is sufficient to issue a decision, we would proceed to do so. Where we think that decisions would need to be escalated or reviewed from a rights perspective, then we will do that. And whatever decision that we take in relation to a rights perspective, and again, we would apply, you know, fundamental rights, but also international human rights standards within that framework. Really looking at, I think, the sort of the tests that are applied to help arrive at the right outcomes and decisions. We would then replicate that across other cases that we take where there are similar issues at play. So that would then inform our own sort of normative framework to be able to move forward with that. Platforms themselves often create large sort of caveats for themselves with the exceptions that they put in place. So obviously we also apply those exceptions where we think they are valid, and we would also look at those exceptions from a rights perspective. There's obviously an enormous overlap between the application of an exception and using a rights-based test to try and assess what the right outcome in a particular case will be. But also where the platforms have made commitments to rights, and many of them have, obviously we take that into consideration as well.
Yeah, thank you. I mean, I had that question because also from the experience of the oversight board, it shows how content policies are also themselves sometimes problematic and not in compliance with human rights standards. And so stopping the evaluation just at platform standards might perhaps be problematic from a human rights perspective. So this is why I was thinking about it. We have two other questions. So another one from Suzanne, that she asks, can you tell us more about your relationship with other actors, notably intermediary services and auditors? Do you have a point of contact in each platform service with whom you can have a direct link?
Yeah, so we have a point of contact in all of the platforms, and all of the platforms that we currently work with, to the best of our understanding. I mean, I don't have an enormous insight into the way they've structured themselves, but they all seem to have created teams which appear from the outside to have sort of members from their legal departments and product and trust and safety and public policy and so on. So they've all created the teams and mechanisms to be able to receive and disputes and identify content and share content back, as well as to talk in parallel about issues relating to data sharing and so on and so forth. And in terms of other actors, we are speaking to and reaching out to sort of trusted flaggers. We've expressed interest and are talking to different, whether they are sort of official vetted researchers, I'm not sure, but different, particularly actors within academia, to try and explore how over time we can make our transparency reporting more granular and more useful. I mean, we completely recognize that this first report, although it does have some interesting insights, doesn't offer the depth of data and the breadth either of the data that would really be needed to utilize it sort of within more meaningful research activities. So we want to get to that point. We want to be releasing data as frequently as is relevant, and to really allow third parties to, like vetted researchers, to make maximal use of it. Auditors we have not started speaking to yet, but we will. We hope to do so over time. And again, I think that becomes again more relevant once we get to a place where decision data is of that breadth and depth that it is utilizable for identification of systemic risks.
Thank you. I think we have a clarification on a previous question. So sorry, it wasn't clear. Interstitial and monetization were different questions. I'll rephrase the monetization question. Will you handle monetized content or accounts that shouldn't be? Likewise, are you taking or will you take cases when platforms demonetize content that is not violated? That is not violated, yeah.
Yes, we are bringing that in now. Advertising, monetization, that is coming into scope for us, yeah.
Excellent. I see other people that are typing their questions. I have made notes, but I need to rethink a bit about my own thoughts on this. I don't know if anyone else is. Oh, yes, another question that is still related to the previous one I asked. So you said that there is now this ODS network and that you are exchanging and collaborating, but I suppose each body would tackle similar questions, but perhaps in a different ways. Is this something that is beneficial to the wider DSA ecosystem, or should there be more harmonization among, dispute settlement bodies and the way they handle disputes?
I think there is value in different approaches being tried out, and maybe sustained over the long term as well, and giving more variance and choice to users in the type of dispute that they raise, but what kind of outcome they're seeking from those. We haven't, as a network, sort of we've had discussions about sort of whether we are going to seek greater sort of harmonization, and I think there are ways that we can all learn from one another. But I also think as a group we're very focused on the fact that we've all got our rules of procedure, which are published and which have been certified by national digital service coordinators and so on and so forth, and obviously we wish to apply those and to do so in an accountable and transparent manner. So there's certainly room for lessons learning amongst one another, and that is one of the stated aims of the ODS network as we move forward here.
Thanks. So we have another question in the chat. Would you make any changes to Article 21 if you could, now that you're putting it into practice?
Bastian, that's a really good question. I haven't thought about that previously. Actually, we've just been really focused on getting things moving. I mean, the answer to this, I guess, has an enormous amount of hindsight in it. But now that we are learning sort of even more granularity, and I have to say this with the context that Article 21 is probably one of the better elaborated articles within the DSA, but I think even more granularity on things like signposting and data sharing, they would certainly be areas for where we would like to see sort of more speedy progress. Some of that may be sort of more secondary legislation or just standards to be put in place rather than actually in Article 21 per se, but certainly these areas that definitely need to be clarified in the shorter term for us to be able to, as I say, reduce the number of default decisions, make sure that users are getting better decisions in the shorter term.
Thank you so much. And will there be a database of decisions? Would decisions be published at some point?
Again, and a question that has been sort of discussed, I think. I believe actually the User Rights Academic Advisory Network had that in one of their papers, if I remember correctly. Ideally, I mean, that would be a nice destination to get to. At the moment, for the Appeal Center Europe, we are not publishing decisions. So we in our transparency report, we want to give a sort of a flavor of, through anonymized decisions, like to be able to share what it is that the type of decision that we're receiving and what kind of outcome we're issuing. But we don't, our stance at the moment is that the decision is between the parties, and therefore we're not intending to publish them. But certainly this is not the first time I've been asked whether we'll publish them, and it's not the holy grail for us not to publish them, right? So we're open to dialoguing on that. A shared database would be great. I think we've got other shorter term, issues we need to tackle first before we get there. We also need to, discuss as a network how we triage cases between ourselves and try and ensure that we are removing vexatious or duplicate disputes and so on and so forth. So there's a lot to get to. The list is long, but we will get there in the end.
Thank you. And while there is another one that just appeared, so let me read it. Hello, Thomas and all. Thank you for your presentation. Negative effects on civic discourse is considered one of the systemic risks platforms can present, according to the DSA. Who are the epistemic authorities assessing what systemic risks are? If it's the trusted flaggers, do you believe there is a possibility that the assessment of such risk might be politicized?
Well, my understanding is that the obviously platforms have to raise systemic risks, and the auditor then reviews them, and the regulator will then review those audit reports and feedback on those. So I think that is the chain in terms of the process. I don't think it's up to trusted flaggers or out-of-court dispute settlement bodies to sort of name what those systemic risks are. And we certainly very much see our role as we're not an advocacy organization. We're not responsible for identifying systemic risks, but we will be putting data out, and where we think there are challenges, right, we will be calling those out, but it'll be for other parties within the regulatory framework to sort of name them as risks and require the platforms to report on them and demonstrate how they're mitigating them.
Thank you. Suzanne, another question. So you mentioned Poland as a country where there was more content contestation. How can we explain it?
We've found that the users, but also civil society in Poland, are just very active comparatively. You know, they've obviously we have both per capita, but also in total number, a high number of disputes, but not in a way in which Poland is sort of vastly outstripping other countries in terms of the numbers of disputes that have been submitted. So I think it's just a combination of sort of active civil society and maybe better user awareness, which could be connected to sort of media reporting and attention. Again, I would counsel, the transparency report shows some interesting data, but I don't think this is going to necessarily be the constant picture that we see as we go through a year and 2 years and 3 years and onwards.
Thanks. I take the opportunity to ask another question, which I just thought about. So last week, we held a workshop, a full-day workshop on titled Hack the DSA, where different groups worked on different aspects of the DSA and looked at transparency reports and so on and so forth. And one question that came up was whether ODS are under an obligation to produce a public transparency report. So we then checked the article, and our understanding is that the report is only to be submitted to the digital service coordinators. So is that reading correct? And if so, has Appeal Center taken the deliberate choice of publishing a public report for everybody?
Yeah, so we are required on an annual basis to report to the DSC. That report is as you've noted, directly to the digital services coordinator. I have to say I don't recall clearly whether the DSC is then required to publish the report. I don't think that's in the legislation, so I think you're correct there as well. But I want to go back and just double check that myself. And the answer to your other question is yes. So we have decided that we will put out transparency reports, and we will do so as frequently as we can. Obviously, this one is covering sort of the extended first half of 2025. We want to make sure that we sort of increase the frequency over time. That in part should be built around the sort of the relevance and the usefulness of the data and the use of the data by third parties. But I would really like us to get to a sort of a situation where we are also sort of able to issue bespoke reports or reports in relation to different periods or elections in particular countries, or reports that match the needs of academics and researchers if they're exploring different topics, or even media. Now, it's going to take us some time to get to that point, but I think if we're not releasing that kind of data, then we're really missing an enormous component of what out-of-court dispute settlement can offer to the wider regulatory framework and just to other third parties and actors, whether they are part of the regulatory framework or not. So yes, we will continue to publish reports, and we have set ourselves up on a data sharing basis in order to be able to do so.
Thank you. Thanks so much for your answer. We have a few more questions. So Neil, he says, thank you for your reply. Do platforms share with you how their content moderation and data annotation practices are carried out? Do we know how many content moderation sites there are in Europe?
No, they don't share
details. For a platform like Meta instance, yeah.
Yeah, and I don't know how many content moderation sites that they have in Europe. Yeah, sorry. That information has not been shared with us. We've also not requested it. I think if we did, we might be told that it's not relevant to out-of-court dispute settlement. But yeah, I can't answer that question. I'm sorry.
Thanks. Perhaps there is something in the transparency reports published by the platforms themselves, but I'm not sure if I recall this. The report's been quite long and rich in numbers and data. We have another question. How should ODS bodies determine the applicable law when assessing allegedly unlawful content? And do you at Appeal Center, in addition to Platform 7 condition, determine the applicable law?
How does bodies determine it?
It's the penultimate one.
Yeah. So we look at policy violating content, right? So actually we do not look at national legislation when we are reviewing a particular dispute. So although fundamental rights and international human rights and even in some cases sort of pan-EU or national legislation may help inform our normative framework, we're not actually directly applying those laws when we look at decisions themselves. So the decisions are sort of across all jurisdictions in the EU per platform.
Thanks. Thank you. Another question, if you receive an appeal on a content that was published by a third party, for example, because the user asking you wants it to be removed or because its notice wasn't taken into account, do you try to contact the third party, or more generally, how do you take into account third parties' rights?
So so obviously under the DSA there is a provision for third parties to represent users. We will be activated, or we have activated that. We will certainly want to make that facility available. In terms of do we try and contact that third party? If the third party submits the dispute, then yes, we're in contact with them. I don't necessarily think we would go back to I mean, it depends on the dispute, I guess. Yeah, I hope that answers the question.
I think we are receiving perhaps a reply via the chat. We only have a few minutes left, so if you have any burning questions, this is your moment. And yes, let us know in the chat. We will be concluding in 7 minutes. I'm sorry, I feel my question wasn't clear. So let's imagine user A flags a content from user B, but the platform doesn't act on it. So user A appeals the decision to you. Are you trying to contact user B in the process whose content could be deleted?
Oh, I see. No. That we consider to be an action that the platform was responsible for.
Yeah, so the case is still between the user and the platform and not user A against user B. I suppose this is, yeah.
In theory, user B might not be happy with the outcome of a particular action that the platform takes in response to a decision and may appeal that, right? They may also then themselves, in theory, come to an ODS and say, well, my content in this case, I guess, was removed and wish to dispute that. But no, we wouldn't include the third party in the dispute itself. Bastian, thank you for clarifying. I feel I've not been very good with answering your questions. I think so apologies for that.
And so in that case, let's assume that, user A flags the content, they win the case, and then user B complains that their content has been wrongly removed. Would you take into account the precedent decision, or would you treat it as a separate issue? Like knowing that the dispute has already been decided. I don't know if this has happened, but I suppose it's a potential.
It is a potential. Again, I don't have a formal response on this in relation to our rules of procedure, but I think it would constitute a dispute, a new dispute. Now, of course, ideally we would be connecting the two together and maintaining the same outcome, right? Not changing the outcome. And I'm pretty sure the platform would flag to us if we came back with an inconsistent decision. But my sense is that it is another dispute, right? Because essentially the user has the right to challenge the decision of a platform, and that is a decision by the platform, whether informed by a decision from an out-of-court dispute settlement body or not. It's still the platform's decision. So I think it would be. This is maybe one of the cases where, over time, as we build more sophistication, we can figure out solutions which, we do not want sort of endless circular processes of disputes being raised and things never being closed off, or we don't want vexatious disputes or duplicate disputes. And so we really want to make sure that we are supporting users to make, in as many cases as possible, eligible disputes that is worth their time and sort of worth the time of the regulation of the ecosystem, if I can put it that way. But yes, this is one of those sort of ways in which you find odd processes and paths through the legislation.
Yeah. Excellent, thanks. So thank you so much for your very interesting presentation and your detailed answers. This was very informative and amazing. We could learn directly from you. Maybe we meet back in 5 years to discuss the progress or stagnation on the DSA implementation. So yeah, it could be a date and we can meet again and see the progress that we have made in the next 5 years.
Yeah, Susanna, I think unfortunately I have to say I think you're probably being realistic by saying 5 years, but I hope we can meet again in a year or maybe 18 months or 24 and know and see progress and know that this is actually much more effective. But five might be the realistic time period here.
I think our time is almost up, so I will wrap it up. Thank you. I want to warmly thank once again Thomas Hughes for having joined us today and for having shared his insights and expertise with us. I also take the opportunity to thank my colleagues, Suzanne Vernel, who is the chair director, and Garance Denner, who is a project assistant, for their help in organizing this event. Our next Lunch and Learn will take place on the 4th of November from 12:30 to 1:30. It will be held in French, so we're going back to French for the next one, and we will have the pleasure of welcoming Benoit Loutrel, who is a member of ARCOM, with whom we will be discussing the role of ARCOM in the wider DSA machinery. So thanks once again, Thomas, for your availability. We have learned a lot today, and we will be posting the recording of the event for those who could not join us live, so they will be able to catch up on this later.
Stefania, thank you very much, and thank you for all the questions as well.
Thank you everyone, and have a good afternoon and a good rest of the week.